Only people can file a criminal complaint. There are only 4 ways a court can hear a criminal complaint. 1 or more of the people sign a sworn affidavit that they have been injured and seek a grand jury indictment. 2, the sheriff or coroner can directly ask the grand jury for an indictment through a sheriff's inquiry. 3, the prosecutor, on behalf of the government or the people, can bring an accusation before the grand jury, and the grand jury can either indict or do nothing. 4, the grand jury, by its own will, can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. And if it finds wrongdoing, it can present it to the court, and it must go to trial. No one can second guess the grand jury unless the grand jury's actions violate another person's unalienable rights. Consent of authority. We read in the Declaration of Independence, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these rights are life, liberty, and the pursuit of happiness, that to ensure and secure these rights, government are instituted among men, deriving their just power from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. codes, Title 42 and Title 18, and liable for damages under U.S. code and common law." Consent to indict. The Fifth Amendment states, "No person shall be held to answer for a capital crime or otherwise infamous crime unless on a presentment or indictment of a grand jury." Therefore, our servants, government, requires the people to get an indictment. Grand jury, judge, servants have no authority to make a ruling or a judgment on people, masters, without the people's consent. In legal terms, when the judge of a court, not of record, asks you, "Do you understand?" he means, do you stand underneath his authority of his court? So, if you say yes, you just gave him or her jurisdiction over you. Nevertheless, if the person standing before the judge is not informed of the court's intent, the judge would be subject to charges of fraud. Only the people can judge. Our U.S. Constitution only authorizes common law courts, aka courts of record. A court of record removes the power of a judge to make a ruling. His or her role is that of the administrator of the court, aka a referee. The final decision maker is the tribunal, who is either the sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? The answer to that is no. Every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow men without his consent. Cruden versus Neal. Herein is liberty. If you do not give the court consent, they have no jurisdiction over you. Judges may judge in equity courts. Equity courts are contract disputes. If the dispute is over $20, both parties must agree to an equity court. Judges in the equity courts must proceed under the rules of the common law governed by the American jurisprudence and United States Supreme Court decisions. Common law is the law of the land. All cases which have cited Marbury versus Madison cases to the Supreme Court have never been overturned. See Shepard's citation of Marbury versus Madison. The Constitution was ordained and established by the people for the United States of America, aka government. Thus, government was created by an act of the people. Therefore, the creation cannot trump the creator. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional. Marbury versus Madison, 5 U.S. 137, 1803. Therefore, that status which would deprive a citizen of rights of person or property without a regular trial according to the course and usage of the common law would not be the law of the land. Hoke versus Henderson, 15 N.C. 1525 AM DEC 677. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona 384, U.S. 436, 491. No emergency is just cause to suppress or suspend the Constitution. While an emergency cannot create power and no emergency justifies the violation of any of the provisions of the United States Constitution or the state's constitution, public emergencies such as economic depression for especially liberal construction of constitutional powers, and it has been declared that because of national emergencies, it is the policy of the courts of times of national peril so liberally to construed the special powers vested in the chief executives as to sustain and effectual the purpose thereof, and to that end also more liberally to construed the constituted division and classification of the powers of the coordinated branches of the government, and insofar as may not be clear, inconsistent with the Constitution. 16 Am Jurisprudence 2D, Section 98. Constitutions must be construed to reference the common law. Summary proceedings are null and void. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in a sense of a national customary law as distinguished from the common law of England adopted in the several states, in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution would not be understood. 16 Am Jurisprudence 2D, Section 114. Supreme law is the basis of all law. All fiction of law is null and void. Nisi prius courts rely on statutes, which is fiction of law, which seeks to control the behavior of the sovereign people, who are under common law. No statutes and who not common law, not statutes, and who ordained and established the law. Therefore, legislators cannot legislate the behavior of the people. No provisions of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical, for certainly the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come into conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a near nullity or a fiction of law. 16 Am Jurisprudence 2D. The common law is the real law, the supreme law of the land. The code, the rules, regulations, policies, and statutes are not the law. Self versus Ray. That's RHAY 61 WN 2D 261. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The general rule is that a unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the enactment. Excuse me. And not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed, such as a statute lives as question that is purported to settle just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. The general principles follow that it imposes no duty, confers no rights, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no act performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provisions of the repeal of the prior law will usually fall with it and will not be permitted to operate as repealing such prior law. The general principles stated above apply to the Constitution as well as the laws of the several states insofar as they are repugnant to the Constitution and the laws of the United States. 16 Am Jurisprudence 2D, Section 256. Due process. The Russian Constitution provides the following rights for the citizens: the right to work, the right to rest, the right to maintenance, the right to education, the freedom of conscience, the freedom of religion, the freedom of speech, the freedom of the press, and the freedom of assembly. But what the Russian Constitution lacks is the right of due process. Due process is the right to be heard in a court of justice. Due course of law. This phrase is synonymous with due process of law or law of the land, and means law in its regular course of administration through courts of justice. Kansas Pac Rye Co. versus Dunmire, 19 Kansas 542. No person shall be deprived of life, liberty, or property without due process of law. A similar provision exists in all the states' constitutions. The phrase due course of law and the law of the land are sometimes used, but all three of these phrases have the same meaning, and that applies conformity with the ancient and customary laws of the English people or laws indicated by the Parliament. Davidson versus New Orleans, 96, U.S. 97, 24, L.ed. 616. Due process is the unalienable right that protects all of our rights. If due process is lost, the only remedy left for the people is the Second Amendment. It is the sheriff's duty to make sure it does not come to that, but it does appear to be close. Due process requires an indictment before being tried. Our county jails are filled with people who were never indicted. Amendment 5. No person shall be held to answer for a capital crime or otherwise infamous crime unless on presentment or indictment of a grand jury. Black's Law defines an infamous crime as a crime that carries a jail sentence. Due process requires a trial in a court of record. City, town, or village courts are not courts of record. Our county jails are filled with people who were never tried in a court of record. Due course of law. This phrase is synonymous with due process of law or law of the land, and means law in its regular course of administration through courts of justice. Kansas Pac Rye Co. versus Dunmire, 19 Kansas 542. The United States Supreme Court said concerning courts of record and courts not of record, the former being those whose acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony, and which have power to fine or imprison for contempt. Courts not of record are those of inferior dignity, which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. 3 Blackstone's Commentary 24, 3 STEPH Commentary 383, the Thompson Fletcher CCGA 24F period 481, Ex parte Thielston 52 California 225, and Irwin versus US DCGA 37F period 488, 2L period R period A period 229, and Hinger versus Davis, that's Heininger versus Davis, 96 Ohio State 205 117 N period E period 229 231. Due process requires a trial by jury. Not a jury trial, a trial by jury. Our county jails are filled with people who have never been tried by a jury. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Due process is not a summary conviction, which is a summary proceeding by a judge or magistrate. Our county jails are filled with people who were sentenced by summary conviction. Summary conviction. The conviction of a person, usually for a minor misdemeanor, as the result of his trial before a magistrate or court, without the intervention of a jury, which is authorized by statutes in England and in many of the states. In these proceedings, there is no intervention of a jury, but the party accused is acquitted or commended by the suffrage of such person only as the statute has appointed to be his judge. A conviction reached on such a magistrate's trial is called a summary conviction. Brown Blair versus Com 25 GRAT VA 853. As to the construction, with reference to the common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense of a national national customary law, as distinguished from the common law of England adopted in the several states, in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. 16 Am Jurisprudence 2D, section 114. Due process requires a lawful warrant before a person's property can be searched or property seizure. Many people have been abused with unlawful warrants, otherwise identified as capiases. Amendment 4. The right of the people to be secured in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Due process of law requires that tax seizures have a warrant with a wet ink signature of a judge supported by a sworn proof of claim, oath, or affirmation. Many lives are destroyed by unlawful tax seizures. Non-judicial foreclosures are without due process. Many homes are taken by unlawful foreclosures. By the law of the land is more clearly intended the general law, a law which hears before its a law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. Dartmouth College Case 4 Wheat, U.S. 518, 4 ED 629. No man shall be deprived of his property without being heard in his own defense. Kinney versus Beverly 2 Hen and M VA 381 336. If the people are going to be incarcerated, if people's homes are going to be searched, if people's homes are going to be seized, or if people's bank accounts are going to be seized, it must be done lawfully, or America is no better off than an authoritarian state. It is the sworn duty of the sheriff, being the chief conservator of the peace within his territorial jurisdiction and chief executive and administrative officer of the county, to know when the people's unalienable rights are being violated and to protect them by preventing these acts of lawlessness. Let them get a lawful warrant if they can. Irrevocable conflict between statutes and constitution is to be resolved in favor of the constitutionality and the beneficiary. In all instances where the court exercises its powers to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. Thus, a state is not to be declared unconstitutional unless so Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clear incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as the unconstitutionality should be resolved in favor of the constitutionality and the beneficiary. 16 Am Jurisprudence 2D, sections 255. Liberty is a blessing. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. So fucking important. Our posterity, ladies and gentlemen. Do ordain. Ordain is biblical. Okay, God ordains things, all right? The Heavenly Father ordains things, all right? And establish this Constitution for the United States of America. The preamble to the Constitution for the United States of America is, in fact, a trust. It's letting you know it's a trust. It's telling you what the grantor's intent, the grantor settlers' intent was for we the people, all right? And I've had a lot of legal scholars argue with me, Derek, that doesn't... The preamble isn't law. You're right. The preamble isn't law in the sense of legality. Where it is law is the intent of the grantor and the testator. Okay, it's their intent to establish domestic tranquility, to ensure that justice be established, to make sure that the liberty is preserved to ourselves and our posterity, all right, by securing these blessings, ladies and gentlemen. That's so important to be able to comprehend this, is a trust, all right? Now, you can opt to be lawless if you like. You can choose to be a heathen. I'm fine with that. That's your business. You don't have to adopt necessarily the things that I say. I would ask you to take it under consideration, maybe. But you don't have to adopt the things that I say, and you don't have to believe the things that I say. But just let me read this one more time. We, the people of the United States, in order to form a more perfect union, all right, to make sure that clean across the board, everybody is what? That justice is established for everybody, ensure domestic tranquility throughout the lands, provide for the common defense, right? To make sure that women that are being abused have somewhere to go in order to seek shelter and to make sure that they're no longer going to be accosted against their will or abused, right? Or men for that matter. Promote the general welfare, right? The general welfare of everybody, and secure the blessings of liberty to all, to ourselves and our posterity. Do ordain and establish. Okay, we are ordaining it. We are establishing it. This is a fact. We're going to swear our sacred honor upon this compact, and we're going to sign it. The people that signed this were then and there headhunted. The king put out a bounty on everybody's head that was pushing for this. Remember that. Freedom isn't free. It comes at a great cost. Do ordain and establish this Constitution for the United States of America, the preamble to the Constitution for the United States of America. That's what tells me this is a trust document. People go, well, are you a signer to it? Are you a party to it? How can you be a party to something that was created 250 years ago? Well, if you're looking at it in contract law, I'm not a party to it. I'm not privy to it at all. But if you're looking at it through the eyes of equity and you understand that this is a trust, this was a grantor-beneficiary relationship. And if you can identify that and you can explain that and you can express the trust, well, by golly, then it's a trust. And the beautiful thing about a trust is nobody has to know the trust even exists. Okay, the beneficiary doesn't have to be notified that they're the beneficiary. A trust will not fail for want of a trustee. This is a trust, ladies and gentlemen. I can't be any more clear about it. So you can acknowledge and accept the trust, or you can deny it. I don't care what you do. The choice is yours. Do your own research and see what you come up with within your own mind after studying Gibson, Pomeroy, Joseph Story, John Marshall. Once you study all these people and realize that they were big on trusts, once you realize that the Federal Reserve is a trust system, everything is put in trust by the elitist. Okay, America has lost its way, and only a virtuous people can guide her back. And so to that end, the people, by the mercy of God, must rediscover the common natural law and, with his blessing, return America to her roots again. Now, I don't want to start that because that'll take me hours tonight. Fuck it. All right, to prove my point, are you guys ready? I'm just going to ask some questions. I'm going to answer my own questions, and if you have a conflict with how I answer them, you can put it in the comments. And I'm not doing this necessarily for anybody in particular, but if the Declaration of Independence says that all just powers of government derive only from our consent, and we do not consent to anything, then aren't the criminal laws the only thing that can be enforced against non-consenting parties, since they don't require our consent to enforce? And the answer to that is yes. The problem with the structure of the question is criminal laws. Criminal laws apply to policy enforcers, to the legislator, to the Congress, all right? A tort, an action of violating somebody's rights, is applicable, and we are answerable to that. So murder, rape, sodomy, theft, all those things, we are answerable for, and we can be brought into a court, all right? But there's a due process for bringing us in, all right? So just because I don't adhere to the statutes, codes, city ordinances, rules, and regulations does not mean that I am a lawless man or that I'm a heathen by any means, because the law that I operate on is is much more solid and fixed upon sound doctrines and principles. Don't harm, rape, murder, maim, damage anybody for any fucking reason, and honor the agreements you make. Those are the laws that I abide by, all right? And do your best to convey with great dignity and honesty the truth. Always be true. Certainly, if we do not want protection or benefits, privileges, and immunities of being a statutory civilian, okay, statutory civil citizen domiciled on federal territory, then there ought to be a way to abandon it and the obligation to pay for it, at least temporarily, right? The answer to that is absolutely. One can be protected by the common law without being a person under the civil law. If one has a right to not contract and not associate, then that right begins with the right to not procure any civil statutory status under what the U.S. Supreme Court calls the social compact. Okay? It's a social compact that they're presuming and assuming that you entered into. All right? All compacts are contracts, yet that doesn't make such a person lawless, because they are still subject to the common law, which hasn't been repealed. If the word permanent in the phrase permanent allegiance is in fact conditioned on our consent and is therefore technically not permanent, as revealed in Title 8 U.S.C. subsection 1101A31, can't we revoke it either temporarily or conditionally, as long as we specify the conditions in advance, or the specific law we have it for and those we don't? Yes. All that is required is to notice the government that you don't consent. Everything beyond that point becomes a tort under the common law, a trespass against your unalienable rights. And that's where notice to agent is notice to principal, and notice to principal is notice to agent comes into effect, that maximum, all right? If the separation of powers does not permit federal civil jurisdiction within states, how could the statutory status of citizen carry any federal obligation whatsoever for those domiciled within a constitutional state, the Union of States, and outside of a federal territory? Quite simply, ladies and gentlemen, they don't. Federal civil and criminal laws has no bearing upon anyone other than public officers, volunteers who wish to be classified as United States citizens. And again, you're not even a United States citizen until you become naturalized, okay, which involves a procedure, a process, within a constitutional state. Those officers, in turn, come under federal civil law by virtue of the domicile of the office they represent and their consent to occupy said office under Title IV U.S.C. subsection 72 and Federal Rules of Civil Procedure 17. Otherwise, Rule 17 forbids quoting federal civil law against a state citizen domiciled outside of the federal territory. If domicile is what imparts the force of law to civil statutes per Federal Rules of Civil Procedure 17, and we don't have a domicile on federal territory, okay, so we have to ask ourselves, what is federal territory? Federal territory is Washington, D.C., the District of Columbia, otherwise identified as the District of Criminals, okay, Guam, Samoa, the Virgin Islands, the Outer Minor Lying Islands, so on and so forth, and its territories, right? Then how could we, in turn, have a civil status under the laws of Congress, including that of citizen or residence? Quite frankly, ladies and gentlemen, you cannot. The only reason people believe otherwise is because of propaganda and untrustworthy politicians of the government designed to destroy the separation of powers that is the foundation of the Constitution. Isn't a non-resident, non-person just someone who refuses to be a customer of specific services offered by government using the civil statutory code franchises? Why can't I choose to be a non-resident for specific franchises or interactions because I don't consent to procure the product or service? The answer to that is yes, you can deny it. You can opt out of specific franchises by changing your status under each franchise. They all must act independently or the unconstitutional conditions doctrine is violated, okay? And where do we get that authority, or where do we affirm that we have that authority? What can we write down that would affirm where our source of authority comes from? We could write down Article 1, Section 9 of the federal Constitution, and in every state there is a amendment that is in the Bill of Rights that is just the same in every state. All 50 states have it in their Constitution. Article 1, Section 9, and also Article 1, Section 10. You have the right to contract unlimitedly without the intrusion of government or any other private entity interfering with your right to contract. Well, if you have an unlimited right to contract that is protected because it's an unalienable right, then you also have the right not to contract. You also have the right to terminate contracts, okay? It's not only affirmed in the Constitution, it's affirmed biblically, and it's just logic. Practical, reasonable, common sense. Any reasonable, prudent man would understand that if I entered into a contract and it's not mutually beneficial for all parties involved, full disclosure wasn't had, and now the contract is seemingly causing I, a man, harm, I have a right to get out of the contract, all right? I have a right to shut it down, especially when it's with a political subdivision, because you're not actually contracting with any one man, woman. You're actually contracting with an entity, and that entity hasn't signed anything per se, and thus granting you the right in a unilateral situation, a unilateral contract, to go ahead and quash it, restrict it, do a revocation of signature, and opt out, okay? If the national and citizen of the United States at birth under Title 8 U.S.C. subsection 1401 involves two components, being national and citizen, Why can't we just abandon the citizen part of the specific transaction by withdrawing consent and allegiance from those transactions or relationships? Wouldn't we do that by simply changing our domicile to be outside the federal territory, since civil status is tied to domicile? The answer to that is yes. You own yourself and your property. That right of ownership includes the right to exclude all others, including government, from using or benefiting from the use of your property. All right? Later on, we'll come back. I got like 78 of these questions and answers, and they're all very straightforward. I think they would help each and every one of you out greatly. And I'm going to take the time to wet my whistle and smoke a cigarette. We'll come back and we'll hit some more of these questions for you guys. And again, I'm just doing this to help plant seeds, to help you guys ascend to the mind, to find your own way. Can I write documents for you? Sure, I could. Would it do you any good? Probably not. And the reason for that is by the time that you had those documents submitted into the court and you were questioned by anybody who is learned in this, they would quickly come to the realization that you didn't write the documents. So now you're in there purging yourself. And you don't quite understand it just yet. So writing your documents for you would just be a disservice. But providing this information and allowing you to ascend to the mind to write your own documentation, now that's something, all right? My mentors don't often tell me the answers. They provide the literature, they allow me to read it, we have discussions and conversations about it, and then I write my documents. And they criticize and critique, and constructive criticism, of course, with me to help me ascend of the mind. The way that I see things isn't necessarily the way they see things, and that's okay. We can agree to disagree, because when you're truly free, so long as my rights don't violate your rights, like my rights stop where yours begin, then there is no issue. I'm free to be of the mindset that I am and to articulate who I am the way that I see fit, the way that benefits me best. And there is nobody that can pass judgment against me for that, especially the ones who know not who they are themselves, okay? So we'll come back and we'll do some more of this to help provide to you what's really going on. You're being presumed as a United States citizen, partially because you registered to vote, you filled out driver's license information, and you lied on it. You didn't realize that you weren't being forthcoming. You weren't knowledgeable of the facts. But ignorance of the law doesn't excuse anybody, because we're all responsible for knowing the contracts we fucking enter into, people. All right? That's how they're getting the joinder, because we're signing things, not asking fucking questions. Now, if we don't ask them to fully disclose things that we don't understand, who's at fault? At the end of the day, the man signing the document, never asking the questions, is the one at fault. You know, they can cry all day long that they didn't get full disclosure, but here's the bottom line. You didn't ask a question, and if you didn't ask me the question, I was under no obligation to answer, first of all. Secondly, I'm not a fucking mind reader, all right? So, you know, we're letting them off the hook by not asking them to clarify certain sections, and then we're signing it thinking that we know what the fuck we're doing, and in hindsight, we are slitting our own throats and making ourselves slaves. You cannot serve two masters. You cannot do it, for you may love one and hate the other. It's an impossibility. It's a perpetual conflict of interest that many people have been subjected to due to the lack of knowledge. So I hope these videos are helping you guys out. Share them with your friends and family and loved ones, and we'll come back and we'll get into some more questions that are about status and status correction, okay?